We're talking about caveats today to clear up some widespread and common misconception about the use or misuse of caveats and the consequences of lodging a caveat if you don't have a correct interest in that property. A caveat is essentially a notice of claim lodged against a title, so a certificate of title for property, and it puts the landowner and the public or any interested third party on notice that the caveator, being the person that lodged the caveat, may have an interest in the property. I guess the concept being that the Lands Titles Office cannot deal with the property or the landowner cannot deal with the property as long as a registered caveat is on the title. There's considerable cost consequences if you lodge a caveat against a title and you have no proper interest. That extends to damages. So if I own property that has a caveat registered against it and I sell it to an independent third party, I won't be able to proceed to settlement and get the money owed to me for the purchase price if that caveat is still registered against the title. So if there's no valid reason for that caveat to be there, then me as a registered proprietor may lose out on the sale and my damages might be quite considerable. So the caveator would then be at risk of suffering a damages claim for that type of damage. So there's considerable cost consequences of lodging a caveat if you don't have an interest. To remove a caveat, you've got two options. You can apply to the Registrar General for an application to remove the caveat, and that forces the caveator to prove their interest in the property within 21 days. Their failure to do that within 21 days will mean that the caveat will automatically slide off of the title. So that really forces the caveator to issue proceedings in the District or Supreme Court in a very short space of time, and that's the District or Supreme Court that has jurisdiction to deal with these caveatable issues. Costs amount to $10,000 to $20,000 in the first instance. So if you have lodged a caveat without proof, or without having an interest rather, then those costs should be recoverable against the caveator. It's absolutely essential that you get appropriate advice from a suitably qualified practitioner, somebody that specialises in property law, so that you're not lodging a caveat without interest, and more importantly, you're not making an application to remove that caveat in circumstances where the caveator may have a genuine interest. Look, it's easy as picking up the phone and making that initial inquiry. A lawyer could pretty much tell you in the first instance whether there's something to explore there or not. You're not going to incur considerable fees or any fees in the first instance. So as simple as a phone call, making sure that you've got a caveatable interest before you proceed.